law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. We do the show every Thursday, 4 p.m. Eastern Time, live, and then we make a replay available after the fact, after the live show, a recorded replay of the show. This is the one piece of content we produce every week at Law of Self-Defense that is open access. Most of our content is locked down for our members, but we make this one show each week freely available. We'll talk more about membership in a moment. As the name suggests, the news and Q&A show, the first half of our hour, roughly hour together, is self-defense law in the news, things that have caught my eye in the last week. And the second half is the Q&A. Now, we do have a bunch of questions that were sent into us ahead of time that I thought were sufficiently interesting to cover in the show, mostly submitted by our Law of Self-Defense Platinum members. Their questions always get priority. But time permitting, if we can get it in before the top of the hour, I'll also take questions from the live audience. So if you're watching this at the Law of Self-Defense website, or you're watching this on Facebook Live, you can put your questions in the comments, and I'll flip through the comments before the end of the show and pick out questions that I think would be informative for people to answer. Now, we have a bunch of news stories, a ton of content to cover today. So I'll describe the news stories we're covering first to give you all a heads up on what we intend to cover. You can make a decision about whether or not it's sufficiently interesting for you to stay with us for the hour. And then I'll also address the pre-planned questions that we plan to cover, time permitting. So we have a news story on activists who are protesting what they claim is the serial prosecution of a defendant by Baltimore State's Attorney Marilyn Mosby. You may recall Marilyn Mosby from the Freddie Gray prosecutions. In this case, the protesters are very upset that she's prosecuting this black gentleman for the fifth time in a murder trial. What I found interesting about this story is I would bet good money that none of these people who are protesting what may be a persecution of a defendant, a fifth-time murder prosecution, I wonder if any of these people protesting this persecution of this defendant had any sympathy at all for the 6 Baltimore police officers that were persecuted by this same prosecutor, Marilyn Mosby, back in 2015. We'll cover that in some more detail. There's also a news story that I included here today just because, again, it touches on Marilyn Mosby and the 6 officers she prosecuted in 2015. It's a news story about objections to a challenge coin that's been minted in support of those 6 officers. We have another story about the sentencing coming up for Derek Chauvin, recently convicted of murder in the George Floyd case, murder and other charges. And we have an interesting story about stupid people doing stupid things. A father and an adult son get into a shootout and a car crash up, deliberate ramming by vehicle. And of course, that ends up in arrest. But we talk about some of the legal dynamics of that event, particularly in the context of subjective reasonableness, a required element for any use of force. And as I mentioned, we also have a bunch of questions lined up. The questions include, what are the legal consequences of errant rounds, missed rounds that may have been fired in lawful self-defense, but then proceed on downrange? There's no such thing as a miss, folks, right? The round continues until it definitely hits something. We have a question asking about a scenario in which a Texas rancher who's got a hunting cabin goes out to his hunting cabin and finds out it's occupied by 20 male illegal alien squatters. What are the legal implications for his privilege to evict those squatters, particularly, obviously, in the use of force context? We have a question about the Plano, Texas Antifa protest. That's the one where they blocked the road. A bunch of cars were backed up, and a large, angry white gentleman apparently got out of his car, walked up to the head of the line, and started shouting at the protesters. And then there were various threats and displays of force. At least some of the protesters were apparently armed, at least with electronic devices like tasers, perhaps also with firearms. So we talk about that case, answer some questions about use of force implications there. I should also mention, obviously, you know how to catch the show live if you're watching it live. I've told you how to watch the recorded video of the show. New for 2021, we're also making just the audio portion of the show freely available as a podcast. You can get this podcast on any of the major podcast platforms, including Spotify, Google Podcasts, Apple Podcasts. We have links to all of those. It's freely accessible. There's no cost. So in effect, it's a weekly hour-long self-defense law podcast. And you can learn how to access that at lawofselfdefense.com/free podcast. All one word, free podcast. And before we dive into the first of the news, the last thing I need to mention is the sponsor of today's content, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. Folks, if you use force in self-defense, defense of others, and you end up criminally charged, you're looking at a huge legal expense. The most common cases I consult on are aggravated assault cases, meaning a firearm was displayed. Usually no shots were fired, nobody was hurt. And those clients are looking at retainers for their lead counsel of $30,000 to $50,000. And that's only for pre-trial expense, folks. That's not even for trial. And if you've actually killed somebody in self-defense and you're looking at a manslaughter or murder charge, you could easily go through a couple of $100,000 in legal expenses pre-trial. So if you don't have that kind of money stuffed in a mattress, just in case you need to defend yourself, defend your family from a criminal predator, it can be helpful to have the financial backing you need to make sure you can fight that legal battle the way you want it fought, which is as if your life depended on it, because really it does. And that's what CCW Safe promises its members, to cover the cost of their legal expenses if they're involved in a use of force event. Now, I've looked at all these programs that are out there. I found the one that best fits my needs is CCW Safe. I'm a member of CCW Safe. Whether or not they best meet your needs is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member, and folks, if you're a member of a different program, I still urge you to look, because a lot of those other programs out there in the marketplace are, frankly, garbage. They look good. They're marketed well. They're substantively garbage. They're a complete waste of money. So even if you're a member of some other program, I still urge you to take a look at CCW Safe, and you can learn more about what they have to offer at lawofselfdefense.com/CCW Safe. And if you do decide to become a member there, at that URL, you can save 10% off your membership with the code LOSD10 for Law of Self-Defense and the number 10. Okay, so let us now go ahead and proceed with the show proper and start diving into our news stories. So the first of the stories that caught my eye today was these protests that are currently taking place against Baltimore State's Attorney, Marilyn Mosby. She's prosecuting a gentleman called Keith Davis Jr., probably for the fifth time now for murder. He was charged with killing a security guard back in 2015. He's had so far 4 trials. 2 of them resulted in hung juries. And of course, a prosecutor is free to retry a hung jury. One was resulted in a conviction. That conviction was overturned. And then the most recent also resulted in a conviction and a 50-year prison sentence. And that conviction has now been overturned. So I'm not sure what's happening in the Baltimore courts, but nevertheless, now Marilyn Mosby is promising to try Keith Davis Jr. a 5th time for the alleged murder of this guard. Now, I don't want to get into the merits of the case, but I want to use this as an opportunity to talk about prosecutorial power and the abuse of that power. And by the way, folks, on this topic of multiple prosecutions, imagine if this was you. Imagine if you were charged with murder, not for allegedly murdering a security guard, but when what you claim is an act of self-defense, they drag you to court, you go through several $100,000, you end up with a mistrial. So they try you again. You end up with a mistrial. So they try you again. You get convicted, get your conviction reversed on appeal, so they try you again. How much resources do you think you have left for that 4th trial? I mean, really, by the 2nd trial, you're completely broke, to be honest. That's another reason I encourage people to take a look at CCW Safe. To my knowledge, they are the only of the self-defense insurance companies that will continue to provide resources through that entire process. You are not cut off. Even if you're convicted at trial, they will finance your appeal. Their competitors won't do that, either because they lack the resources to do that, or they just tell you up front that they won't do it. This is a real concern, especially with politically motivated prosecutions, that they come back again and again and again as often as they can. And they know, the prosecutors know full well, that if it's your second or third trial, there's no money left for your defense. And that makes you a lot easier to convict. We'd all like to believe that we don't live in a world where how much money you have, how much financial resources you can bring to the legal fight makes a difference in the justice you get. But I'm sorry, it does. It makes an enormous difference. So another reason I recommend you take a look at CCW Safe at lawselfdefense.com/CCW Safe. But back to Keith Davis Jr. and Marilyn Mosby. So the protesters who support Keith Davis Jr. are saying this is ridiculous. He's going to be tried a fifth time for murder. This begins to look like a malicious prosecution, like a personal vendetta, like a persecution of this defendant. And there's a good argument that can be made there. Again, I don't want to get into the merits of this case. I find it hard to believe it's gotten to 5 trials and it has much merit. I would have expected the defendant to have been convicted by now. I guess he's been convicted a couple times, but convicted and had the conviction stick, not been overturned on appeal by now. There was much merit to the case. But the reason this case struck my eye is because I remember when Marilyn Mosby was prosecuting 6 Baltimore police officers over the death of Freddie Gray. Freddie Gray was a street corner drug dealer in Baltimore who was picked up on a drug sweep of his block by a squad of police officers. It was a large effort. By the way, it was an effort requested by prosecutor Marilyn Mosby because her husband was the was the politician for that district in Baltimore. And the residents of the district were complaining about the drug dealing. So the politician husband asked his wife, Marilyn Mosby, to ask the police to sweep the square for drug dealing, which is what the police did. They picked up Freddie Gray, handcuffed him, put him in the back of a police van. And when the police van reached its destination, they found Freddie Gray with a serious neck injury that would result in Gray's death a few days later. Now, it's important to know that there's literally zero evidence that any of the officers charged in this case used any unlawful force on Gray at all. None. Literally zero evidence that any of them used unlawful force on Freddie Gray. Nevertheless, these officers were charged with offenses as serious as second-degree malice murder. Now, when it actually got to trial, when Marilyn Mosby had to prove her case, the first cop was a mistrial, a hung jury. The second cop decided not to go with the jury. He went with a bench trial. He got acquitted by the trial judge. The third cop got acquitted by the trial judge, the same judge in all the trials. The fourth cop got acquitted by the trial judge. And at that point, the judge essentially looked at the prosecutors and said, are we really going to do this 6 times? Because it's the same evidence in every case for every one of these defendants. The outcome's not going to change if the evidence in the law is not going to change. And finally, the prosecutor Marilyn Mosby dropped all the charges against all the officers. The Barack Obama Eric Holder Justice Department found no evidence to support a federal prosecution of these officers. And in fact, the Baltimore Police Department's own administrative review returned every one of these officers to duty. So they didn't even do anything administratively wrong. Yet Marilyn Mosby brought these prosecutions against them. Why? Well, obviously for political reasons only. So I wonder if all these people protesting in support of Keith Davis Jr., saying he's being persecuted by a prosecutor, were protesting in favor of the 6 Baltimore police officers who were persecuted by Marilyn Mosby. Half those officers, by the way, were black. Not that it should matter, but that's the world we live in. And I expect that if you ask them, they'll tell you the people protesting for Keith Davis today were not protesting against Marilyn Mosby's abuse of her office when she was targeting cops. They're only mad about it now because she's targeting, allegedly, Keith Davis Jr. And folks, the bottom line is everyone is entitled to due process of law, and everyone is entitled to not be subject to a politically motivated prosecution. Everyone. And if we deny due process of law to anyone, even people we think we have good reason to hate, we ought not be surprised when it's our turn in the barrel, or the turn in the barrel of someone we support, and they are denied due process of law, or we are denied due process of law. Permitting prosecutors to bring politically motivated cases against people we do not like invariably and ultimately results in that same prosecutor misusing that same power in the same way for political purposes against people we support and perhaps against ourselves. And should not be anybody's idea of what justice is. There's a reason that representations of Lady Justice, right? The statue of the woman holding up a scale, a book, why she's blindfolded, because justice is supposed to be blind and applied equally to each of us. Okay, so that's that news story about the Keith Davis Jr. protest in the context of prosecutorial abuse, persecution of defendants for political purposes. A related news, actually it's an unrelated news story, except it also happens to mention the same Baltimore 6 cop. So this was a news story that was, in essence, an expression of outrage by the journalists that some online vendors, such as Etsy and eBay, were selling challenge coins. I'm sure you all know what challenge coins are. And these challenge coins were commemorating alleged police misconduct. So a cop uses force on a suspect. It's claimed to be misconduct. And someone mints a challenge coin in support of that officer. And the idea is that it's wrong, right? If the police misconduct is wrong, well, the challenge coin should be wrong. And these online vendors should be pressured to not allow sales of these challenge coins commemorating purported police misconduct on their platforms. So one of the challenge coins objected to was for the Baltimore 6, the 6 officers persecuted in the Freddie Gray case. And I'm going to quote from the news story here because I think it's important to hear their actual language. Quote, last year, an eBay senior vice president wrote on social media that there's no place for hate or violence in our community, and we will do whatever we can to effect change. But eBay recently allowed the sale of a coin commemorating riot team's response to unrest in 2015 with the words, the Baltimore 6, in apparent reference to the 6 officers involved in the arrest of Freddie Gray, who died in police custody. That coin just sold on eBay for $366, close quote. Now, of course, the inference here, because the whole story is about challenge coins commemorating police misconduct, the inference is supposed to be that the Baltimore 6, the 6 officers charged in the Freddie Gray death, had committed misconduct, had committed unlawful acts upon Freddie Gray to cause his death or contribute to his death. And as I've already mentioned, of course, there's literally zero evidence that any of the Baltimore 6 did anything unlawful to Freddie Gray, whatever. With, again, 3 of them being acquitted outright at trial, the other 3 having all charges dismissed, the feds seeing no evidence to prosecute, and administrative review returning all of them to their jobs. In short, not one of those officers was ever found to have done anything unlawful, not even administratively wrongful, with respect to Freddie Gray. But despite this reality, every one of those officers will be forever perceived by the public as a bad actor, largely because of maliciously or perhaps merely stupid journalist commentary on the case as found in this news report about these challenge coins. If there's a dumber and less informed class of people generally than journalists, there are exceptions, but generally, I've yet to meet them. Okay, another story I wanted to cover is very briefly, because we'll cover it in more detail, I suppose, as it gets closer. It's still about 3 weeks away, but the sentencing of Derek Chauvin, who was convicted in April of the murder of George Floyd, as well as some other criminal charges brought against him. We're currently in the post-conviction pre-sentencing phase of these legal proceedings, and I did have a question come in a week or two ago about why we do this. What is this phase? Why aren't defendants sentenced immediately upon the guilty verdict? You're found guilty of murder, we sentence you to life, whatever. So let me address how this process works here so you can understand the proceedings. Now, one way to think of criminal trials is as having 3 major stages. The first stage is the pre-trial stage, the preliminary stage, which sounds unimportant, right? Preliminary things are normally things we think of as unimportant. But this is where the evidence and legal arguments are proposed for inclusion or exclusion from the trial. This is where the legal battlefield is defined. So it's very important. Often the fight is effectively run right here at the pre-trial stage. This, again, is where the legal battlefield is defined. So then after this, we have a second stage, which is the criminal trial itself. And if that results in a guilty verdict, then we hit the third stage, which is the sentencing stage. And sentencing is not simple. It's often a fairly complicated procedure, and it can involve the consideration of large quantities of evidence, including evidence that might not have been at all admissible during the trial itself. And typically, states allow for a range of prison time for conviction of serious felonies. And those ranges are embodied in what are called sentencing guidelines. So you look up a crime, it's associated with some level of offense. Class A felony, Class B felony is a pretty common framework. Then you look up Class A felony, and it has a range for sentencing. And with any given range, a wide variety of factors can be considered in determining the specific sentence, such as whether this is the defendant's first offense or their fifth offense, for example. There are other factors that can lead to additional sentencing above and beyond the guideline range, such as if there's a firearm sentencing enhancement, so a gun was used to commit the crime, or perhaps whether the defendant committed the crime from a position of authority, not just a stranger raping a young woman, but the teacher raping the young woman, for example, or in this case, in Chauvin's case, a murder committed while a cop wearing a uniform under color of law. So collectively, all of these factors can be thought of as exculpatory factors that might lead to a shorter sentence, or inculpatory factors that might lead to a longer sentence. And to determine which of such factors may play a role in sentencing requires that those factors and the evidence supporting them have to be argued in court to the sentencing judge so that the judge can make an informed sentencing decision. And often as part of this process, there's what's called a pre-sentencing investigation, or a PSI. That's conducted independent of the prosecution and the defense, and it's presented to the judge, the findings of the report. And also there'll be arguments made by the prosecution and by the defense themselves in open court, in sentencing hearings that will help the judge arrive at a specific sentence. And that's where things currently stand with Derek Chauvin. So the PSI is being prepared. The exculpatory and inculpatory factors are being decided upon by the sentencing judge, the same judge who was the trial judge in the case. And with the arguments being made to the judge by the prosecution and by the defense. And with respect to the arguments made by the prosecution and defense, one can think of these as almost being a form of negotiation, with the sentencing judge being the arbiter. So each side starts off with their most extreme offer first. And often, not always, but often the sentence ends up somewhere in the middle of all that. In this case, the state's arguing for a sentence of 30 years for Derek Chauvin, which is 2 or 3 times the sentence that would typically apply to Chauvin's convictions under the normal application of the Minneapolis sentencing guidelines. The Minnesota sentencing guidelines. They're obviously state-level sentencing guidelines. So what's happening here is normally Chauvin would be looking at somewhere between 10 and 15 years, but the state's arguing there are aggravating factors, like he was a cop in uniform, like the crime was committed in front of children, like the crime was committed with accessories. There were obviously the 3 other officers involved in Floyd's arrest, and that those should effectively bump up the total sentence to 30 years. And of course, the defense is arguing for mitigating factors. So the defense is in effect arguing for 0 jail time beyond times already served, because Chauvin was they say, trusted, faithful police officer for 20 years, has friends, has family, and so forth. Never committed a crime before, things along those lines. So this will all ultimately be resolved on June 25th. So in about 3 weeks, when the sentencing judge, again, same as the trial judge, Peter Cahill, will make the final call on Chauvin's fate, at least absent an appeal or a retrial. Now, the next story I wanted to cover was a weird event, as you'd expect this would have happened in Florida, but I don't believe it was Florida. But a father and son got into a car ramming / shootout with each other. So kind of a crazy story, but it's useful to illustrate how circumstantial evidence is used in these use of force cases, particularly in the context of subjective reasonableness. So subjective reasonableness is, of course, one half of the element of reasonableness, which in turn is one of the 5 elements of any claim of self-defense. Those 5 elements are innocence, imminence, proportionality, avoidance, and reasonableness. And for a use of force to be reasonable, which it must be to be lawful, 2 things must both be true. First, the use of force must have had a genuine, the user of force must have had a genuine good faith belief in the need to use that force in self-defense. If even they don't think it was necessary self-defense, it doesn't qualify. So you need that genuine good faith subjective belief in the need to use force in self-defense. But that subjective belief alone is not enough. That subjective belief must also be objectively reasonable. So a hypothetical, reasonable, and prudent person with the same training, experience, under the same circumstances as the defender would also have shared that subjective belief. An irrational, objectively unreasonable subjective belief is not enough to support a justification for use of force. The subjective belief has to be real, genuine, good faith, but it also has to be objectively reasonable. Now, if the prosecution can disprove subjective reasonableness, can disprove that the defendant had a genuine good faith belief in the need to use force in self-defense, well then, if they've disproved subjective reasonableness, they've disproved the element of reasonableness. And by extension, they've disproven self-defense as a legal justification. So this is often a target of attack by a prosecutor on a claim of self-defense. Now, the challenge with attacking subjective reasonableness is, of course, that, well, it exists inside the defender's head, and we can't see inside their head. So unless they actually tell us what their subjective belief was, how are we supposed to be able to determine subjective belief, subjective reasonableness? Well, what we typically do is we make reasonable inferences about what their subjective belief likely was by looking at circumstantial evidence. Did they conduct themselves in a manner consistent with someone who had a genuine good faith belief that they were facing, for example, a deadly force threat? And in this particular news story, we have two parties, a father, one Rene Omar Guzman, in one car, and we have his adult son, Matthew Guzman, in a second car. And both parties agree that the father rammed his car into the car that the son was riding in. And they also agree that the son fired several shots at the father with a Smith & Wesson semi-auto 9mm pistol. So both those events occurred. Both parties agree. Where they disagree is in the sequence of those events. The father claims that the son shot at him, and then the father rammed the son's car in self-defense. In contrast, the son claims that the father rammed his car and that he then fired shots at his father in self-defense. So absent other evidence, and other evidence does exist in this case, but we're going to ignore it for purposes of this discussion. Absent other evidence, how are we to determine which narrative is more likely to be the true narrative? That of the father, the shot who he says he was shot at first, then rammed the other car in self-defense, or the narrative of the son, who says, hey, we were rammed first, and then I shot back in self-defense? Well, we do it by considering the circumstantial evidence and applying common sense to make reasonable inferences from that circumstantial evidence, which is what Greene County Sheriff Jack Williams does in this case. As the sheriff notes, and I'll quote here from the news story, quote, "The father rear-ended the other car at 80 miles per hour, and if you're being shot at, you'd think you'd hit the brakes and turn around and get yourself out of that situation. The father saying where he was initially shot at was over 1.5 miles away from where the ramming took place. So he continued, even after what he claims were the shots fired, for another 1.5 miles and then rammed them," close quote. In other words, the sheriff is doubting the father's narrative because he's questioning the subjective reasonableness of the father's narrative. A reasonable person tends to distance themselves from life-threatening danger, not close proximity to that danger. So a person who closes proximity to another is engaged in conduct that is inconsistent with having a genuine good faith subjective belief that that other presents a life-threatening danger. Here, the fact that the father admittedly pursues the son's car for 1.5 miles, closing proximity to the point of ramming and disabling the son's car, suggests that he did not have a genuine good faith belief that his son presented a deadly force threat, and that in turn suggests that the ramming occurred first and the shots were in fact a defensive response. And that's why the sheriff here ultimately secured a warrant for the arrest of the father and not for the arrest of the son, because of that circumstantial evidence, which was more consistent with the son's narrative and inconsistent with the father's narrative, and the father's inconsistent with the father's claim of a subjectively reasonable fear of deadly force harm. And by the way, folks, this dynamic also applies to any of us who might decide to pursue an aggressor, like the father here apparently pursued the son. Once you start going to the fight, rather than the fight coming to you, it doesn't much look like self-defense to anybody. Oh, by the way, folks, I forgot to mention at the start, but each one of those news stories will be linked in the text version of today's content and the transcript of today's content over at the lawofselfdefense.com blog. So if you're interested in reading the original stories for any of those, you'll be able to do that there. And I should mention also, before we get to the Q&A portion of the show, if you like this kind of content, you can get it more often than once a week, folks. We produce content for our members on an almost daily basis, doing this kind of legal analysis, usually in a much more detailed setting, rather than covering a bunch of different stories. Usually we focus on one particular story, use of force event, court decision involving use of force law. But that content's accessible in text, video, and podcast form only to our Law of Self-Defense members. The good news is that Law of Self-Defense membership is dirt cheap, especially to just try it out. If you'd like to try out Law of Self-Defense membership, you can do that for 2 weeks for the very modest cost of 99 cents. And that gives you the same access to our content as if you were a full-blown member. There's no restriction on your access to our content. So there's literally years worth of legal analysis on use of force, news events, cases, court decisions, and more. Again, in text, video, and podcast format. And if you decide you don't like it, in that 2-week trial period, just cancel your subscription. We'll give you 200% of your money back. If you decide to stay a member, it's still only about $0.25 a day, folks, to be a Law Self-Defense member. So still very inexpensive. If you'd like to give that a try, and I encourage you to do that, you can point your browser to lawofselfdefense.com/trial. lawofselfdefense.com/trial to take advantage of that 99-cent 2-week, 200% money back guarantee, Law of Self-Defense membership. All right, let's get over to the Q&A portion of the show now. First, we had a bunch of questions, and this happens every week. I guess it's unavoidable. But folks, our expertise here is use of force law. When are you permitted to use various degrees of force in defense of yourself, in defense of others, in defense of property? What we don't cover here is gun law. Gun law is completely different. Gun law is, when do you need a license for a gun? What kind of license? What kind of gun? Where can you carry? Where can't you carry? What are, ammo requirements? What are magazine limits? We don't cover weapons law, gun law in particular. So if you send us questions on gun law, this is the response you're going to get. We do, of course, get a lot of actual gun law inquiries, people involved in gun law issues, and we refer those to other attorneys. So if you're facing actual legal liability on a gun law issue, and of course, if you're a Law Self-Defense member, then certainly reach out to me. It's not the kind of case I would personally work on, but I can find you a competent attorney. This also applies to rights restoration cases. I know a lot of lawyers who do great work on those cases. I don't work those cases, but I can refer you. So if you've had a gun purchase denied because of a NICS issue, or perhaps in your youth you were convicted of a felony and you'd like to get that record cleared so you could buy a gun lawfully, I can certainly help with that by referring you to attorneys who do that work. But that's not the kind of work I do. The kind of work I do is use of force law. Also, when we cover these questions, it's important to keep in mind that it's very rare in the law for there to be absolute 100% certainty, black and white answers, yes and no answers. It's almost invariably a sliding scale between legal liability and no legal liability, and you rarely bump up against the ends. You could be the most innocent defendant I've ever had in my office, and if we put you in front of a jury, there's a 10% chance you're getting convicted. That's just part of the noise in the system. Innocent people do get convicted. So there's no way to guarantee a particular legal outcome. So what we're looking to do is to conduct ourselves in self-defense, defense of others, defense of property, in a way that pushes us as close to zero legal liability as possible. You can't get to zero, but you can get pretty darn close. So that's our goal at Law of Self-Defense, is to help our members accomplish that, get as close to zero legal liability as possible. But generally speaking, you're not at zero. You're also generally not at 100% unless it's a really egregious case. You're somewhere on that sliding scale. So when we answer these questions, we're not literally trying to provide an absolute answer. We're trying to teach you how to think through how the law would apply to these cases so that you're developing a knowledge base that's applicable not just to a specific question, but to use of force scenarios generally. So with that in mind, take a look at the time. Okay, we're doing okay, I think. We got a question from Joe D. from Florida. He's one of our Law Self-Defense Platinum level members. And he asks, what about errant rounds fired in self-defense? So you're involved in a self-defense shooting, you're popping rounds at your attacker, and one or more of those rounds continues on past the attacker. And Joe brings this to our attention through a news story from Vero Beach, Florida, where there was a gun fired inside an apartment, and officials said the rounds went through the closed front door of the apartment. Another round went through a kitchen wall. Another round went through a cupboard. Another round went through a window. And obviously, as we mentioned earlier, there's no such thing as a miss with a bullet. It will continue to travel until it hits something capable of stopping it. So what about those rounds? What's the legal liability associated with those rounds? And I'm sure if you've taken a concealed carry course, a self-defense course, the instructor at some point said something to the effect of, hey, there's a lawyer attached to every one of those rounds. And I'm not sure that's really all that useful a statement. I mean, of course, anytime you're projecting out potentially deadly force, there's naturally potential legal liability with doing that. Strictly speaking, if your firing of the shots was in lawful self-defense and non-negligent, so you didn't, for example, just put one hand over your eyes and blindly fire the gun in the general direction of your attacker, but you're conducting yourself in a lawful way. You're directing the shots deliberately at your aggressor, and one or more shots miss, or over-penetrate or continue on and damage or hurt somebody else, an innocent party. If your use of force was otherwise lawful self-defense and you were non-negligent, there ought not be either criminal or civil liability for that unintended injury. Now, if you conduct yourself negligently, there's certainly going to be civil liability. If you conduct yourself sufficiently negligently, so it's not just negligent, but reckless, which is a criminal degree of negligence, then there can be criminal liability. So you don't want to do that. And of course, again, just like there's never 0% criminal liability anytime, anybody can sue anybody for anything in America, and it's possible that they may win, no matter how meritorious your use of force. So there's no black or white answer here, except I can tell you that where the weight of the law would apply to these scenarios. So strictly speaking, again, if you're firing in the shots with otherwise lawful self-defense, so it's justified in that respect, and it was done non-negligently, which of course is an issue that could be argued in court, whether or not it was negligently or non-negligently. But lawful self-defense non-negligently, there ought be neither criminal nor civil liability for injury caused by those errant shots. Now, in some states, of course, you have the benefit of self-defense immunity provisions, which could be criminal immunity or civil immunity or both, depending on the jurisdiction, that allow this particular issue to be argued out in a pre-trial hearing so you can get the whole self-defense question, the criminal liability, the civil liability question adjudicated in a relatively timely, low-cost manner, a pre-trial hearing, kind of a mini-trial, usually 1 day, 2 day trial-like process, in front of a judge, no jury, just in front of a judge. And if you meet the legal threshold for the use of force having been lawful, the judge can grant you immunity from criminal prosecution and or civil suit, again, depending on the jurisdiction. I certainly am a fan of those immunity provisions. I think they're frankly more important than stand your ground provisions usually for good guy cases of self-defense. So if you live in a state that has those, good for you. If you live in a state that does not, it would be nice if they could be adopted there. Okay, the next question we have is a bit more complicated. It comes from Anthony F. from Texas, again, another Platinum Protection member, and he poses a scenario, and frankly, it wasn't clear to me if this was a real-world event or just a hypothetical scenario. So we'll treat it as kind of a hypothetical. But the hypothetical is that a rancher in Texas has a cabin. It was unclear from Anthony's message if this was could really be thought of as a home or more of a occasionally used cabin for hunting purposes, for example. And the legal implications change depending on that factor. But for the moment, let's treat it as a cabin. He's got a cabin in rural Texas. He visits only occasionally for purposes of tending cattle or hunting deer. And he arrives at his cabin and he finds that it's occupied by 20 males, presumably illegal immigrants in our hypothetical, squatting on the property. Now, when he arrives and he sees this, he can't immediately call 911 because he's outside of cell phone coverage, well outside in this part of Texas, some parts of which look a lot like the moon, frankly. And in this hypothetical, when he ordered the 20 men to leave the property, at first they refused, but then ultimately they complied and they left. And the question is, was the rancher justified in removing these 20 men? And it really depends on what we mean by removing. And because the method of removing matters a great deal, right? That's the conduct that would possibly be subject to criminal liability in this kind of case. Certainly the intruders have no right to be on the property, right? They're trespassers at the very least. And the rancher does have the right to not have them there. The rancher has a right to remove trespassers from his property. But there are hard limits on the manner in which the rancher can remove the trespassers. For example, it would be unlawful for him to simply shoot each one of them in the back of the head and cart their bodies off to the property line. There's also practical and tactical considerations when we're talking about such a disparity of numbers, especially in such an isolated area as described in the hypothetical. And those are tactical and practical implications that are true even if the rancher is armed with a firearm and the men themselves, the 20 men, possess no weapons. So there are times when a use of force may be technically lawful, but would be ridiculously stupid to attempt because the outcome is likely to be extraordinarily negative. Now, first, let's consider the manner, first in the context solely of defensive property. So we're assuming right now that the 20 men are not threatening the rancher. They're simply offending against the property. They're trespassing. So it's a property issue. It's a defense of property issue. It's not a defense of persons issue. The rancher is not under imminent attack. If he were under imminent attack, well, then it's a defense of persons, self-defense, defense of others, if there were others around, and so forth. But in a defense of property context, so assuming the squatters entered the cabin when it was unoccupied, meaning before the rancher arrived. So it's not a case where the rancher's in the cabin and these 20 men break in. The 20 men are there already when the rancher arrived. So it's not clear to me that if this is not a home, but like an occasionally used hunting cabin, it's not clear to me that the Texas special provisions for home defense would apply to this case. Now, you can find, if you're in Texas, you're interested, you can find those provisions. It's Penal Code 9.32, paragraph B, as in Bravo would be the relevant paragraph. And this is a provision that many states have similar special provisions for the defense of highly defensible property, for the defense of home scenario. And what this provision does is it creates a legal presumption that the defender in the home dealing with a forceful and unlawful intruder into the home, it's legally presumed that defender has a reasonable fear of an imminent deadly force attack that would justify his use of deadly defensive force against that intruder. Basically, it gives the home defender everything he needs to justify the use of deadly defensive force against that forceful and unlawful intruder. So it's a very powerful defensive home statute. Again, not unique to Texas. Many states have these legal presumption in defense of highly defensible property provisions. But this provision, at least the Texas provision, which I reviewed for today's show, explicitly applies only when the home is occupied, meaning occupied by the defender. That is, it envisions a defender inside the home facing an intruder or someone attempting to intrude into the home. It doesn't envision a homeowner who arrives home, to find people already inside the house. And in our hypothetical, that's what happened. The rancher got to the cabin, the people were already there. So the cabin's not occupied by the rancher while the intrusion was taking place. And if that provision, again, Penal Code Section 9.32 Bravo, if that does not apply, because for the reason I just described, then the defense of the home, of the cabin, is really treated as a defense of just least defensible property, a defense of personal property. In most states, that would mean the rancher is limited to using non-deadly force only to remove these trespassers. But I say in most states because we are in Texas in our hypothetical, and in Texas there is a statute that allows for the use of deadly defensive force in defense of even mere personal property. That is Penal Code Section 9.42. In fact, we have a shortcut to that if you'd like to read the Texas Deadly Force in Defense of Property statute. You can point your browser to lawofselfdefense.com/942 if you want to make a note of that. And although that statute has very specific hoops that have to be jumped through, so among those very specific hoops is it only applies if particular crimes, enumerated crimes, are reasonably believed to be taking place. And included among those crimes in this defense of least defensible property provision, 9.42, and I'll quote here from the statute, quote, to prevent the other's imminent commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime. So, close quote. So note that the theft provision and the criminal mischief provision only trigger this privilege to use deadly force in defense of property if they occur at nighttime. The other enumerated offenses, arson, burglary, robbery, aggravated robbery, don't. Arson is not really part of our hypothetical. Robbery and aggravated robbery is the taking of property by threatening a person. And we're presuming for this part of our discussion, there is no threat to persons, or this would be a self-defense case, not a defense of property case. So that really leaves us with burglary as the one enumerated crime here that would trigger this deadly force in defense of property provision. And are the trespassers committing burglary? I mean, maybe, but maybe not. And if they're not, they don't trigger Statute 9.42. So, I mean, if they broke in, and even if they're just eating food found in the cabin, right, which would not be hard to imagine, well, that would be a burglary. They unlawfully entered for the purpose of committing a crime, which is the classic definition of burglary. The crime being essentially the theft of the food, right? Converting the food to their own use. But the rancher is required to reasonably believe that burglary or one of the other enumerated crimes in Section 9.42 is taking place. And if you have to reasonably believe it, it means you can't merely speculate it. You can't imagine it. It's not, well, they could be eating the food. For all I know, they're eating the food. The concern can't be merely speculative. The rancher would have to be able to point to actual evidence from which he formed a reasonable belief. So, for example, did he see these men eating canned goods of a kind he keeps in the cabin? That would likely be enough to form a reasonable belief that the men were committing burglary, the eating of the food. But he can't really speculate that the men must be eating his canned goods, absent evidence, and conclude from that speculation that burglary is occurring that would trigger the deadly force privilege under Section 9.42. Now, all that I discussed so far, and I'm going to try to wrap up quickly because we're in the last 5 minutes, that's the legal nuts and bolts on whether the rancher could lawfully use deadly force against a trespasser. That's the kind of analysis we would do in the absence of a threat to person. Again, if it's a threat to person, it's a self-defense analysis, not a defense of property analysis. But it's equally important to ask the practical and tactical question of, even if permitted by law, would the rancher, or should the rancher, want to use deadly force in this context? First, how many of these 20 people is he willing to kill, to clear the property? Is he willing to kill one of them? 5, 10, all 20 of them? Second, if the killings were actually all 100% lawful, which frankly seems unlikely, that doesn't mean the rancher won't be put to the test of a criminal trial. And as I've said, you could be the most innocent defendant in the world. We put you in front of a jury, there's a 10% chance you're getting convicted. That's just the noise in the system. Is a 10% chance of life in prison worth clearing those 20 men from the property, especially when one considers that, let's face it, the rancher could clear him off the property. Let's say he kills them all, clears them all the property, doesn't face a criminal trial, but next month when he comes back, there could be easily a different group of 20 guys on the property again. I mean, how often are we going to do that? What problem is really being solved here? And is taking human life worth solving that problem? Would it even solve the problem? There's also the question of whether the rancher could realistically survive a deadly force fight against 20 men, even if he has a gun and they are unarmed. And remember, the real mission in all these cases is always to make it home alive, not simply to be the victor in the fight, even if that would be lawful. The legal victor is what I mean in the fight. Third, this notion that the property's rural, outside of 911 reception is not very compelling to me, frankly, because, of course, it means maybe the rancher can't call 911 in the moment, but there doesn't seem to be any reason he couldn't simply turn around, drive to where he did have a cell signal, and call from there. So, again, the core mission is to survive these scenarios, and it's not much consolation that your use of force was technically lawful, even if we assume it was technically lawful, if you nevertheless died in the effort. Again, a completely separate analysis would be done if the men were actually threatening the rancher personally. That becomes a self-defense scenario. Then you would just apply the 5 elements of self-defense. Hopefully all of you listening to this are familiar with those 5 elements. Okay, folks, let me take a quick look at the questions in the comments now in the last few minutes we have left. First, I'll check out our members' comments. Yes, no audio. Sorry about that, folks, for the first couple of minutes. Oh, I guess Joe D mentions there's George Zimmerman challenge coins out there too. Again, there's no evidence that George Zimmerman did anything inconsistent with lawful self-defense, hence his acquittal at trial. And James asks about the challenge to the autopsy of George Floyd, that the autopsy was coerced. I'm not going to address that here because I've written about it extensively at the Law of Self-Defense blog already. Okay. Good. Sound is good. Let me look through the comments here. Edward asks if I can comment on the home gun confiscation ruled unconstitutional by Supreme Court decision. I'm afraid I can't, Edward. I haven't read the decision yet. I probably will just from personal interest. But again, I don't claim any expertise as a gun law expert or, for that matter, a constitutional law expert. We do need to be very careful. So I do encourage people to read those opinions, those gun opinions, because often they pivot not on the issue we might think is pivotal, maybe not even on a Second Amendment issue per se, but on some Fourth Amendment issue, some search and seizure issue that is relevant in that case and might be the key to the Supreme Court decision, but isn't really a gun law decision per se. All right, folks, I think I've hit all the questions that were in the comments. I am currently planning to do a Law of Self-Defense News and Q&A show next Thursday on our regular schedule. That would be June 10th. I will, however, be traveling. I'm uncertain what the internet situation will be like. So it's possible that the internet situation may be such that I can't stream a live show. I won't know that until the day of, unfortunately. So plan on joining us next Thursday, June 10th, 4 p.m. Eastern Time for the next Law of Self-Defense News and Q&A show. And if it doesn't happen, you'll know why that was the case. But even the worst case scenario, if we don't have one on June 10th, we will have one on June 17th. All right, folks, as always, as I sign out, I remind all of you that if you carry a gun, so you're hard to kill. That's why I carry a gun, so I'm hard to kill. My family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. All right, folks, until next time, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.